Welcome to Infringe at Your Own Risk.
Welcome back to Infringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. My name is Kevin Rosenquist, and today we're tackling patent trolls. Who are they? What do they actually do? And how can inventors protect themselves without getting dragged into costly fights? Rand, welcome back.
Thank you, Kevin. It's good to be back.
All right, so we all trolls has become a term that we're all pretty used to in a different way. I've never heard of a patent troll. What does that really mean in the legal world?
What a patent troll means depends who you are and what side of the fight you're on. It's a pejorative that's used to accuse somebody who's enforcing a patent right that somebody thinks is excessive. And where it was applied, so inventors invent things, they get a patent. They'll often license it, sometimes they won't. Often they don't have the resources either to exploit the patent or to enforce it. And so years ago, some people had a business model and they said, look, let's go and buy up as many patents as we can cheap. Find all these patents that nobody's exploiting. And then we'll go out and we'll look for people who are infringing those patents. And then they got these big pools of patents together, and then they would just start going looking at companies. Okay, are you infringing any of our patents? Are you? And they would go through, and then they would find people who would infringe a patent. And sometimes technology, caught up to somebody's patent. Somebody had a patent, and if you read the patent claims, it covers, A, B, and C. Well, as technology expanded, now everybody's using A, B, and C. Well, the people who own those patents can now demand royalties. And so these people who had all these patents that they had bought up would go and just start going after companies. And they, would go in and say, okay, I want $500,000 or we're going to sue. The problem is in some jurisdictions, it is very, very difficult to get a patent case dismissed prior to the end of discovery. Well, discovery can cost hundreds of thousands of dollars, sometimes millions of dollars. So if you're getting sued on a patent, even though you're positive that you don't infringe, but you can't get out of the case until you're spent $500,000 on discovery, it's worth it to pay the other guy $250,000 to go away. And so some of these companies that were, I think, less than ethical would just start accusing everybody of patent infringement. And,
just throw it all at the wall.
You're going to get $250,000 just to get rid of them, right? And if you do that enough times, you can make a lot of money.
Yes.
Now there are other ones who have gotten groups of patents together, and they're legitimate. I mean, they actually go through, they check, they have a reasonable basis before suing someone for infringement. But accused infringers in patent cases don't like whoever is suing them. Natural.
Yeah, I think it's probably pretty much across the board in the legal
so
world.
It's like, you're a patent, you're a patent troll, meaning you're going after all these entities. Well, sometimes that person may be a patent troll, sometimes not. I had a case years ago where I had a guy who invented this very simple little device. It was a charger for cell phones, effectively. And he invented it. He was a blue-collar guy from out of the country, got a patent in his country, then got a U.S. patent on his little charger. Well, as cell phones took off, he got very broad claims in his patent. And as cell phones took off, everybody was infringing the reasonable reading of the claims of his patent. And so we sued 155 companies for patent infringement. And of course, we got, you're a patent troll, you're a patent troll. a lot. But it turned out that, there was at least a reasonably good argument that they were infringing. And we came up with reasonable licensing terms for people to use it. It was actually one of the best times I've had as an attorney, because after he got the patent, he passed away. And so, he said, "Hey, can you look and see if people are infringing my U.S. patent?" And we said, "Sure." And we started looking. We started finding all these companies, and then he passed away. So it left his wife. He'd been a blue collar guy. What little money he had spent on patenting his invention. And after we'd gone through all of this and this had all played out, I got a really nice call from one of his daughters, and she just said, "Thank you very much. You've given my mom a retirement." Mm-hmm. Because with him being gone, they hadn't had much money. She would have just been living on whatever Australia's equivalent of Social Security is. But because we were able to settle with all these companies on a reasonable basis, she got a nice retirement and was able to enjoy time and able to travel to visit all of her grandkids and whatnot. And so we went after all these people, but to the defendants, we were patent trolls because we were suing them. I actually had one time where somebody called up, accused me of being a patent troll, and kind of went off on me, and I just explained the other side. Little did I know at the time that his client was on the phone during the phone call. And I got a call from the client a couple hours later, and I said, "Well, I can't talk to you because as an attorney, I have an obligation to my client or to the public that I don't talk to represented parties without their attorney being present." Right. So I don't just call up the other side in a case. And he says, "Well, he's no longer an attorney or my attorney." I said, "You're sure about that?" He goes, "Yes, I fired him." And I said, "Well, why did you fire him?" He said, "Because he was being unreasonable. I understand your client's point of view, and you're not being a patent troll. You're just trying to enforce your client's rights. I'd like to settle." He laid out terms he was comfortable with. They were really consistent with what we were asking for, and resolved it. So that was good. But
that's great.
There are patent trolls. There are companies that, and the name implies that people who are of questionable ethics in going after everybody to try and extort money from them. And there are states that have laws now that if you're making unreasonable patent demands, it actually gives the defendants some leverage, including their attorney's fees and whatnot. Whether those will be held up ultimately as being legal is a question. But they're out there because there were so many of these. Some of the changes that the Federal Circuit has done and the Supreme Court on jurisdiction has made patent trolling a little less advantageous. It used to be you could just sue people pretty much anywhere they sold a product. And so everybody would sue in the Eastern District of Texas, where the juries are very favorable to patent owners. And now you've basically got to sue defendants where they're headquartered or have regular places of business. So there's been things that have controlled it, but that's what a patent troll means. A patent troll is somebody who sues on patents with a questionable basis for doing so.
Well, how do you tell the difference between a legitimate enforcement and abuse of the system? Because in your example, you guys sued a lot of companies, so I could see why the perception would be there, but it's just a matter of like when the person acquired the patent and what their intentions were.
That's part of it, but mostly it's how they're going after people. I mean, was there a good faith analysis that they infringe? Mm-hmm. I mean, there's some people will still call these, companies that own whole banks of patents and go after people. Some people will call them patent trolls. I don't think they're patent trolls if they're doing legitimate due diligence beforehand and determining, yes, this person most likely does infringe the patent. Mm-hmm. Right? I don't think that's patent trolling. But if you have a computer, you must be violating our patent. Here's a lawsuit. Um, and there are some who were like that. I mean, some of them were just absurd. And if you're in some jurisdiction, it wasn't a big deal. You just filed a motion to dismiss. They couldn't prove that you were infringing. The court would dismiss it. But if you're in one of those jurisdictions that wouldn't grant summary judgment or a dismissal until discovery was over, you just kind of had to pay the extortion fee because it's going to cost you twice as much to get to the point where you could move to dismiss the case as just paying the people off.
Yeah, and that's something that I think, you can't blame the company in a lot of ways for doing it, but it's unfortunate that they have to do that, or that they feel the need to do that. Because if you have a lot of money and you're like, nope, I'm not letting this guy get away with this, then you can afford to keep moving. But if you're a mid-sized company or even a small business, you probably don't want to put that money into the legal fight.
Right. And there are people who litigate on principle. And that can be really good, because if you get hit with a patent troll and you fight them, even though it costs you more, and you win, right, they're going to be less likely to come after you the second time, because they know, because they're spending money too, or time, right? If they've got to pay their attorneys to fight it as well, and if a whole bunch of people say, we're not paying you, we're going to court, then suddenly they're spending $500,000 per company, or a sizable amount of money. So it's, it's very fact dependent on whether it's legit. I mean, the one thing is these patent pools or banks do serve a beneficial basis, because you get someone who got a patent, can't figure out how to exploit it, which happens quite frequently, especially with small inventors. So I've got a patent. I had a good idea. I know how to make the product, but I don't have the money to make the product. I mean, an industrial mold can cost 20 grand easily.
And we've talked about that previous
20 grand to make a mold, to make this, and do all that. Well, if after 5 years I say, this just isn't going anywhere, I'm just going to forget about it, and somebody comes along and says, hey, we'll pay you $5,000 for your patent. Hey, sure, take it, right? I at least get my $5,000 back. And so there's a benefit to that. It's just when people are making specious patent claims to extort money from people, that's not doing society any benefit. And so that's what people have tried to squash, and sometimes it works, sometimes it doesn't.
Have you defended people who are defending themselves against the patent trolls? How does that generally go down in court? Like, is it pretty, like, if it's obvious that someone just recently bought a patent and is now suing a bunch of people, it's hard to defend that you're a troll in that scenario, right?
Well, if they got the patent, they're suing a whole bunch of people, then you go in and say, okay, how good is their case of infringement? And there's times when it's absolutely clear that there's no infringement. I mean, to me, at least. And fortunately, I practice in jurisdictions that don't have these formulaic rules where you have to complete discovery before you can move to dismiss. And so I'll go right into the court right off the bat and say, here's my motion to dismiss. Their patent requires A, B, C, D, and E. We do not do C or D. And you get declarations and all this. And, sometimes the judge says, is this premature? And they weigh it. But if it looks like somebody is a troll, the judge is going to be more likely to take a look at it and say, okay, turn to the other side. Show me what evidence you have that Mr. Bateman's client does C and D. And if you can't show me at least a reasonable argument that you think they do, I'm going to dismiss the case. And if you can do that, your client's in at $10,000 to $20,000, not $250,000 to $500,000.
Right. Yeah.
So yeah, those are very gratifying when you win those.
I bet.
So
I bet. Yeah. Battling against the trolls.
You feel like, despite being a lawyer, you have contributed to society.
Despite being a lawyer. So this is obviously a thing out there in the world, this patent troll. Are there any recent court decisions, changes in patent law that affect the ability of trolls to operate?
Well, a couple of the things that have affected them. Number one has been the jurisdictional changes. The firm that I clerked at in Dallas 30 plus years ago when I was in law school, they got the decision from the federal circuit that said basically in a patent case, you can sue a business effectively anywhere they're doing business, right? If you have jurisdiction over them, you can sue them there. And so then suddenly you could sue them all over the country. And then a few years ago, the Supreme Court said, no, that's not really the law. It has to be either their official place of business or where they have a regular and established place of business. So not nearly as many companies can be sued in the Eastern District of Texas, right? Toyota can't be sued there because they sold a Toyota there, because they don't have an actual office in the Eastern District of Texas. And so that moved cases out of the very favorable Eastern District, where plaintiffs or juries are very pro-plaintiff, to places like San Francisco, where it tends to be the opposite. A lot of cases are now filed in Delaware because a huge percentage of large companies are Delaware organizations. And so, the poor judges in Delaware probably didn't realize what was coming their way when the Supreme Court ruled that, because I'm sure that their patent docket just exploded. Because I mean, I'd never had a case in Delaware before that, and I hadn't seen that many. There were other hot spots, Northern Southern District of California gets a lot because you have a lot of tech companies out there. Texas got a lot. And some other places, but now Delaware gets a huge number just because that's where all these corporations are organized. So that's the biggest change. And then, like I said, there's some of the states that passed laws that give the defendant rights. For example, Idaho has a law that if there's a bad faith patent assertion, that's what it's called, you get treble damages. The defendant does, and damages include attorney's fees. So if the Idaho law stands up, if you sue me and there's not a basis and I prove that, I can come back at you. And if I spend $250,000 proving it, you may be writing me a check for $750,000. Well, if you're a patent troll, you probably don't want to be messing with a lot of companies in that type of jurisdiction, because it can get
I would say so. That seems like a pretty easy fix, or maybe not fix, but certainly a heavy deterrent.
Yeah, and so it's going to be interesting to see how the courts rule on the constitutionality of those laws. Can a state pass a law like that, and does that interfere with the Patent Act, which is a federal law? Because if it interferes with it, then it's deemed to be preempted under the Constitution. But if it doesn't, then it would give patentees a big club to swing back, or not patentees, I'm sorry, defendants a big club to swing back at patent trolls.
Yeah, I would say so. Wow. Interesting stuff. I've never heard of this before. So very, very fascinating episode, Rand. Thanks for that. And thank you for joining us on Infringe at Your Own Risk. If you've ever wondered how to protect your business from baseless patent claims, or want to make sure your own patents stand up to scrutiny, visit batemanip.com, connect with Rand and the team. And of course, don't forget to subscribe to our channel, leave us a review. We love having you here. Thanks so much, Rand. Really appreciate it.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.